Hello, and welcome to Chapter 6 in Healthcare Supervision. We're going to be talking about the legal aspects of healthcare management. We're going to start on page 108, and let's look through that introduction there. Understanding the laws that affect the workplace is the responsibility of each health information management manager. Traditionally, most organizations operated under the employment at will concept. Now, basically what the employment at will concept is that employees can be fired at any time for almost any reason based on the idea that in turn that employee could quit at any time and for almost any reason. So it was a two-way street. I could quit anytime I want to, and you could fire me anytime you wanted to for almost any reason. But over time, aspects of the employment at will concept led to discriminatory practices by employers. Companies would not hire persons of a particular religion or nationality, and persons were fired for non-work related reasons, such as refusing sexual advances or developing a disability. Now, in this chapter, we're going to talk about the major laws that impact the U.S. workforce and the implications the laws have on interviewing, counseling, and progressive discipline practices in the healthcare workplace. Dropping down into that paragraph, it says, knowledge of employment laws allow a manager to act with confidence and assurance, but should never be a substitute for advice and recommendation from a human resources department or legal counsel. When in doubt as to how to proceed on any legal matter in the workplace, consulting with an expert in employment law is the first step to take in making a decision. Enforcement of many employment laws is handled by the U.S. Equal Employment Opportunity Commission, the EEOC. This is a federal agency with the authority to investigate discrimination claims, render decisions, and file lawsuits if necessary. So, let's get into some of the employment laws that actually impact healthcare. So our first one is the Americans with Disabilities Act. Now, this act was passed in 1990, and it was amended in 2008 with passage of the Americans with Disabilities Act Amendment Act. So the ADA prohibits job discrimination against people with disabilities. According to the ADA, a disability is defined as a physical or mental impairment that substantially limits one or more major life activities. Now, it talks about what a major life activity is. So it includes, but it's not limited to, caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, and working. So we cover a lot of different items there. Being confined to a wheelchair would be an impairment of the major life activity of walking, but wearing glasses for nearsightedness would not be considered an impairment of a major activity of seeing. So again, it's has to be a major life activity. Now, in order to be protected in the workplace by the ADA, an individual must have a disability as previously defined and also be able to meet the job requirements of the position with respect to the necessary educational background, skills, licenses, and employment experience. An individual must be able to perform the basic job duties of a position with or without reasonable accommodation. Accommodation in this case means a change or adjustment to a work environment that allows a disabled employee to perform basic job duties. Reasonable accommodation means the adjustment cannot place an undue hardship on the employer. In other words, the accommodation cannot be too disruptive or expensive for the employer to implement. The concept of an undue hardship will vary among employers. An accommodation that is too expensive to implement for a small physician practice may not be too expensive for a large healthcare system. And so we have some examples of reasonable accommodations. So job restructuring, part-time or modified work schedules, acquisition or modification of equipment or devices, adjustment or modification of examinations, training materials, or policies, and the provision of qualified readers or interpreters. Now, in most cases, identification of a reasonable accommodation will come from the impaired employee as they have the knowledge and experience to determine what accommodations will work best. If a reasonable accommodation is not readily apparent, a manager may ask an employee for suggestions as to what might assist the employee in performing the basic job duties required of a position. Now, the ADA prohibits discrimination not only against individuals with disabilities, but also against individuals because of a family, business, or a social relationship with someone who has a disability. Discrimination covers the following employment practices: so recruitment, pay, hiring, firing, promotion, job assignments, training, leave, layoff, and benefits. And so enforcement of the Americans with Disabilities Act is provided by the EEOC. Remember, that's the Equal Employment Opportunity Commission. All right, let's move on to our next law. We're going into the Civil Rights Act of 1964. And again, you can go through all these slides. So Civil Rights Act of 1964 is an anti-discrimination law that prohibits employment discrimination because of race, color, religion, sex, or national origin. Discrimination is not allowed in the hiring, promotion, termination, compensation, training, benefits, or other privileges of employment. And we're going to further define each one of these elements. So, race and color may appear to be the same thing, but according to the Civil Rights Act of 1964, they are different. Discrimination based on race includes skin color as well as other race-related characteristics such as hair texture or facial features. Skin color can vary among members of the same or different races or ethnicities. Discrimination is not allowed on the basis of lightness or darkness of skin tone. Now, national origin. This refers to ancestry, birthplace, culture, or language characteristics of an individual. Language characteristics include accents and English fluency. Accents and fluency may be considered in the hiring practices if they interfere with job performance. For example, an accent may not affect the job performance of a clinical data analyst, but English fluency may impact the job performance of an HIM professional hired by a vendor to give product demonstrations or provide customer service training. All right, moving down to sex. This is where we're going to get into some very interesting stuff. So, discrimination on the basis of sex refers to gender and is expanded to include pregnant women. Discrimination may not occur based on pregnancy, childbirth, or related obstetrical medical conditions. Discrimination on the basis of sexual orientation is not specifically covered by the Civil Rights Act of 1964. However, the EEOC has clarified the interpretation of gender to mean lesbian, gay, bisexual, and transgender individuals. Laws regarding sexual orientation discrimination are also passed at the state and local levels of government. Now, sexual discrimination, or sexual harassment, I should say, is a type of sex discrimination. The EEOC defines sexual harassment as unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of sexual nature when submission to conduct is made, either explicitly or implicitly, a term or condition of an individual's employment. So if I say, well, you're going to get fired if you don't perform sexual favors for me, then that's what that's meaning. If it's a condition of your employment, you do it or you get fired. Second, submission to or rejection of conduct by an individual is used as a basis for employment decisions affecting such an individual. So again, I tell you I'm going to give you a job if you perform sexual favors. So that's what that one means. And then the last one, such conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. So let's keep going and we'll learn more about that one. So one type of sexual harassment is quid pro quo. Now, quid pro quo is about one person using their authority over another to demand some kind of sexual favor in return for job actions such as a promotion, hiring, or continued employment. A supervisor may tell an employee that a promotion or a pay raise is contingent on them dating or the employee performing sexual favors for the supervisor. Sexual harassment can occur between individuals of the same or opposite sex. Now, the second type of harassment is creation of a hostile working environment. This example of sexual harassment is less obvious than quid pro quo. A hostile work environment occurs when one employee's behavior is interpreted as being offensive by another employee. A hostile work environment may include unwanted touching or unwelcome jokes, language, emails, or text. It may include sexually explicit pictures posted or circulated in the workplace. In general, there must be a pattern of unwelcome actions. A coworker who makes one lewd comment about another is not perceived by most reasonable people as creating a hostile work environment. However, making continued comments, especially after being asked to stop, could result in a charge of sexual harassment. All right, so let's move on to religion. So we're going to go back up to the top, religion. Now, religious discrimination refers to a person's religious beliefs or lack thereof. In addition, the law requires employees to provide reasonable accommodation for religious practices. Examples of reasonable accommodations might be a flexible schedule allowing time off for religious holidays, providing a place to pray, or accepting religious dress or grooming practices. Accommodations for dress or grooming might not be possible due to safety considerations in the workplace. For example, long hair, facial hair, footwear, or headdress may be a safety issue in certain environments where a sterile field is necessary or machinery is used. A manager should work with the employee to determine if an acceptable accommodation exists. All right, now let's go down to retaliation. Now, the Civil Rights Act of 1964 prohibits workplace discrimination against employees and applicants based on their race, color, sex, religion, or national origin. The law also prohibits discrimination against individuals because of their marriage or association with someone of a particular race, color, national origin, sex, or religion. The Civil Rights Act of 1964 protects an employee or applicant against retaliation. This means that if a person complains to their employer, files a claim of discrimination, or participates in an investigation, then their employer can be charged with discrimination. The person cannot be fired, demoted, or otherwise penalized for their actions. A person who reports discriminatory acts or other illegal activity is called a whistleblower. A whistleblower is protected by both a specific federal statute, the Whistleblower Protection Act of 1989, and provisions within individual legislation. So basically what happens is, let's say you're being sexually harassed, or you know that your supervisor will not hire anyone of a specific race, or because of an accent, or because they're pregnant. You know that this is happening, and you report it. If they have that claim filed for discrimination and they are charged with discrimination, then you, as the whistleblower, they can't fire you, they can't demote you, they can't, they can't do anything legally to you because you were a tattletale. Let's put it that way. Okay, next one. And again, enforcement of this act is provided by the EEOC. Now, Civil Rights Act of 1991 basically strengthens the Civil Rights Act of 1964. Now, if you look about halfway through that paragraph, or within just a couple of sentences in, it says, if discrimination is found to have occurred, depending on the charge, the employee could receive back pay, be reinstated, or be awarded a promotion. Now, the Civil Rights Act of 1991 takes possible actions by the employee farther by allowing for jury trials and increased monetary awards for the employees. Employees may now receive compensatory damages for discriminatory actions against them. These damages cover the actual financial loss of the employee and could cover repayment for lost work time or payment for medical bills. Now, punitive damages can also be awarded to the employee as a way to further punish the employer and prevent their employees' discriminatory behavior from continuing. It is important that punitive damages are large enough to deter the employer from allowing the discriminatory behavior to continue. So in those two types of damages that you would receive, compensatory means they're making up for what they caused a lack in. So if you were on suspended for 6 weeks without pay, then the compensatory damages will pay you back for those 6 weeks. That's what it was talking about when it said back pay. Or you may get a promotion, and that's going to help offset some of the costs that you had. Now, punitive, it's not so much for the employee that was discriminated against, it's against the employer that did the discrimination. So it's more punishment for the employer, not so much a benefit for the employee, although it is. All right, so let's talk about age discrimination. So the Age Discrimination Act of 1967 prohibits discrimination on the basis of age against individuals age 40 and older. Now, what it says is that the ADEA permits employers to favor older workers based on age, even when doing so adversely affects a younger worker who is 40 or older. So in other words, a 47-year-old employee cannot claim that they were discriminated against on the basis of age if a 53-year-old was favored in the hiring or promotion situation. So if you're both over 40, you can't claim discrimination even though I can favor both of you. Now, I possibly could get in trouble if I had a 30-year-old that was also up for a promotion, but if you're both over 40, then even though I may favor both of you, the 30-year-old can't claim discrimination either because of this Age Discrimination Act. That's crazy. Now, one thing that I thought was interesting too, and I don't guess I've really ever thought about this, but the start of that second paragraph says that the Age Discrimination and Employment Act also affects retirement issues. And it says that mandatory retirement was initially required by the ADAA at age 65, but then it was raised to the age of 70. So we were, between 1967 and 1986, you were required to retire at the age of 70. You had to retire. Now, the 1986 amendment removed the mandatory retirement age altogether as long as the person was still able to perform the job. Because of certain job requirements, some professionals, such as police officers and firefighters, are allowed to mandate retirement by a certain age. You don't want an 85-year-old police officer or an 85-year-old firefighter. You don't. They can't physically handle the demands of the job. And it also says, it talks about how older workers are sometimes offered early retirement incentives. In these instances, employees are usually asked to sign a waiver that prohibits them from filing a claim under the ADEA. So if it's costing your company a whole lot of money in retirement benefits and then their health insurance and things like that, then sometimes it's more cost effective for you to go to that employee and say, hey, we're going to offer you this incentive to retire now. And then you're kind of saving yourself money because they retire, they're not getting their salary. They're probably still going to have some of their retirement or their health insurance benefits paid for by the company, but you're no longer paying into their retirement account. And again, you're not paying that salary, so it kind of evens out or works to the employee's favor. All right, let's talk about the next one, Family and Medical Leave Act of 1993. Now, this allows employees to take unpaid time off of work for specific family and medical reasons that could include the following. So, the birth of a son or a daughter, or the placement of a son or daughter with the employee for adoption or foster care. So, if you have a baby, or you're adopting a baby, or you're fostering a baby, then you can have that FMLA time. You have a sick spouse, a sick child, or a sick parent that has a serious health condition, then you can take FMLA. A serious health condition that makes you unable to perform your job, well, you can take FMLA for that as well. And then for any qualifying exigency arising out of the fact that a spouse, son, daughter, or parent is a military member on covered duty or called to covered active duty status. So those are some of the reasons why you can take that unpaid time off. Now, an employee is eligible for this benefit if they worked for the company for at least 12 months, so you've had to work there for at least a year, and have worked at least 1,250 hours during that previous 12 months. An employee may take up to 12 weeks of unpaid leave time during a 12-month period. Now, under some circumstances, such as for planned medical treatment, an employee may take the leave on an intermittent basis rather than consecutive weeks. So let's use this example. If I'm giving birth to a baby and I decide I want to take 6 weeks off, then I take that 6 weeks off in one big chunk. I get 6 weeks off of work. But let's say I have breast cancer and I'm going to go have chemo treatments every week for a year. Well, I may want to take off 2 days a week for the course of my treatment. And so that's intermittent. So I may take off Monday and Tuesday because I have my treatment on Monday and it's going to make me real sick on Tuesday. But by Wednesday, I can get back to work. Then I'm going to work Wednesday, Thursday, Friday. So that's what it means when it's talking about continuous. I'm taking full 6 weeks for birthing my baby. Or intermittent, I need to take 1 to 2 days off a week because I'm having chemo for the next 6 months. Okay? All right, let's move on to the next one. All right, this is our Fair Labor Standards Act. Now, this is more commonly known as a wage and hour law. The FLSA is a federal law and is the basis for many state wage and hour laws. When it conflicts with a state law, the more stringent law applies and is administered by the Wage and Hour Division of the U.S. Department of Labor. The intent of the FLSA is determine minimum wage and overtime pay rules, as well as establish a definition of a work week. While wage and hours worked are monitored closely by HR and payroll departments, it is important that the HIM professional and leadership positions have a familiarity with the legal requirements. Now, you have 2 categories of employees that when we're talking about overtime pay. Okay, you have those that are exempt from overtime pay and those that are not exempt or non-exempt from overtime pay. Now, the best way for me to explain this is if you are salaried, which usually comes with higher positions in a company. We're talking about executives, administrators, professional positions like HIM managers, HIM directors, and so on. These people are salaried and they are exempt from overtime. They do not receive overtime pay. Now, non-exempt employees do receive overtime pay. These are going to be the people that are called hourly. If you get paid an hourly rate, you are going to be eligible for overtime. And overtime is 1.5 times the regular rate of pay for all hours worked over 40 hours in a work week. So let's use this example. Myself, I was a manager in the HIM department. Well, I was salaried. So if I worked 45 hours in a week, I only got paid for 40 because I was exempt from overtime pay. Now, when I first started working there, I was an hourly employee, and if I had a system upgrade and I was going to be working over here and there and coming in the middle of the night during the overtime or the downtimes for our system update, and I worked 45 hours in that week, I got 5 hours of overtime pay. So I got time and a half for 5 hours. Now, that kind of sucks in a big way for those salaried employees because they typically have more responsibility and they may spend more than 40 hours a week at their job. However, one of the benefits that we've always talked about at North Mississippi was, let's say I did have a big week and I still had to come in and do that system upgrade, and I was here from midnight to 5 a.m. and then I may have went home for an hour and took my kids to school, and then I come back and I work 8 hours. Well, that's a whole extra 5 hours that I work from 12 a.m. to midnight. If everything was in good condition by Friday, then maybe I could go ahead and leave early and, not necessarily even things out, but I could leave a few hours early on a Friday. Or if I had a really big week and I was at work for 50 hours one week, then my boss may give me Friday afternoon off and I may only work 35 hours the next week. So that's kind of a compensation bit there for your your exempt employees. Now, your non-exempt, as many overtime hours as they can have, and they get paid that 1.5 hour of pay for all hours worked. Now, let's drop down in that next paragraph. Overtime pay also becomes an issue for a manager when working with flexible scheduling. Now, a manager must be aware of overtime regulations when using compressed work weeks, flex time, and job sharing. So let's talk about those. So a compressed work week. Most of the time, a standard work week is 5 days, Monday through Friday. Now, if for some reason I was a single parent and I just needed that extra day to either be with my kids or get my grocery shopping done or, schedule doctor's visits and things like that, then maybe I could talk to my boss and I could say, hey, I would really just love if I could work Monday through Thursday, 10-hour days, or maybe I'll work Monday and Tuesday and take Wednesdays off and work Thursday, Friday, but I want to work 10-hour days. So I'll work 4 10-hour days instead of 5 8-hour days. I'm still getting my 40 hours in, but it's a compressed work week. I have a 3-day weekend technically instead of that 2-day weekend. This sometimes will help. It's basically a help for the employee more than the employer per se. Now, then we have what we call flex time. So this is a work schedule that gives an employee some choice in the pattern of their work hours. Now, usually in any business, there's a core set of hours during the day, whether you have more walk-ins or think about a restaurant. Most people are going to come in around lunchtime. So let's say between 11 and 1, that's a busy time for a lot of restaurants. And then again around supper time. So let's say between 5 and 8, that's another core time of business. So in healthcare, or let's talk about the HIM world, let's talk about people coming in to get copies of their medical records. Let's say those core hours is between 10 and 2. Well, flex time would allow my employee, let's say she has 2 young kids and they both have sports after school. So if they have practices on Tuesdays and Thursdays, then maybe she can come in at 7 a.m. on Tuesdays and Thursdays and leave at 3:30. And on Monday, Wednesday, Friday, when they don't have anything after school, she can work 8 to 4:30. So that's kind of what your flex time is. You have flexible start and end times, but again, it's centered around that core business hours. And then the last one we have is job sharing. Job sharing is basically where 2 or more people share one full-time position. So if I'm a scan tech and I only want to work 4 hours a day, and then we got another person in the department and they only want to work 4 hours a day, and we can kind of work it out to where maybe I work the morning hours and he or she works the afternoon hours, then it's still one full-time position because you're getting 8 hours a day out of the position, but it's job sharing. So 2 or more persons sharing that full-time position. Okay, so we're going to move on down to HIPAA. So we all know about HIPAA, Health Insurance Portability and Accountability Act of 1996. Now this impacts the healthcare workplace in many different ways. So HIPAA is federal legislation that was enacted to provide continuity of health coverage, control fraud and abuse in healthcare, reduce healthcare costs, and guarantee the security and privacy of health information. Now, dropping down into that next paragraph, a couple of sentences in. However, an HIM manager must also be aware of the aspects of HIPAA as it pertains to employee actions in the HIM department. Title II of HIPAA, Preventing Healthcare Fraud and Abuse, Administrative Simplification, and Medical Liability Reform, details the privacy rule. The privacy rule requires that patients' protected health information, or PHI, be made available only to the providers that has a proven need for access in regards to treatment, payment, and healthcare operations. And if we go over to the next page, it talks about the security rule, how HIPAA Title II also covers the security rule. The security rule, again, similar to the privacy rule, but it only applies to PHI in an electronic form. So privacy rule talks about PHI, any type of PHI, whether it's paper, electronic, whatever. But the security rule only applies to PHI in an electronic form. All right. HIPAA also addresses issues of employee health insurance portability and accountability by allowing employees to move from one job to another without losing insurance coverage or being penalized for pre-existing medical conditions. That originally was what HIPAA was. It allowed employees that if they hated one job and they moved to another, that there would not be gaps in that coverage. So most health insurance is paid ahead of time. So if I am working at a hospital, I'm making my January health insurance payments in December. So if I leave my job on December 31st and I have another job lined up that's going to start on January the 15th, well, the whole month of January is going to be covered by my previous health insurance because I've already paid for the month of January. And then when I start my new job, I can start my new insurance and I will never have a gap in coverage. All right, and just remember that enforcement of HIPAA is done through the Office for Civil Rights. All right, let's look at our last law here. So we have COBRA, Consolidated Omnibus Budget Reconciliation Act. Now, this affects employment practice because it offers continuing health insurance coverage for qualifying employees that have lost their health care coverage. So, if an organization offers a group health insurance plan and an employee leaves the organization, they're given the opportunity by the organization to continue their health insurance coverage. Now, the employee must assume payment for the insurance premiums, but does so at the organization's group rate. Now, the cost of the group plan rate is much less than if the employee tried to get insurance out in the open market. So, what happens with COBRA is if, let's say, I retired a couple of years shy of being eligible for Medicare. Well, for that couple of years, I can continue to pay at the organization's cost, which it's definitely more money than what I would have been paying had I continued to be an employee. But I would continue to receive that coverage for up to a year and a half to 3 years. But again, I am continuing to pay for it, and it is a little bit of a higher premium. But then when my Medicare kicks in, I can end that COBRA coverage. So basically, that's what that is. It just allows them to continue that insurance coverage when they might not be able to get any other insurance coverage, or it's a less expensive option than going out and getting your own coverage until you can be covered by Medicare. All right, now let's look at applying equal employment opportunity principles over on page 115. So it talks about in the top, once the HIM manager understands employment laws, the next step is to use the knowledge to develop sound management practices and implement them in day-to-day responsibilities. And so this is where we get into our personnel policies and we get into interviewing employees. So we're going to kind of talk about each one of those in detail. Now, policies and procedures. So we know that a policy is a governing principle that describes how a department or an organization is supposed to handle a specific situation. And a procedure is the series of steps that details how we're going to implement that policy. Now, policy and procedure manuals are usually developed by the HR department in conjunction with attorneys specializing in employment law. The manual should be made available to all employees at every level in the organization. So everyone should be seeing the same policies and procedures for the organization. Hard copy manuals should be placed in each department or workstation where they are easily accessible by all employees. Many organizations publish their policy and procedure manual in a secure location on the organization's website or intranet. Policies and procedures are their best when maintained and current. Manuals should be reviewed annually at a minimum, so at least once a year, or whenever changes are made. So sometimes you update a policy or you update a procedure, so maybe at that point you want to go through your manual and make sure everything else is up to date. Now, let's get into interviewing. you're going to have an assignment, not specifically for Chapter 6, but for Chapter 8. Chapter 8 gets into recruitment, selection, and retention. But you're going to need to come back to Chapter 6 when we get to that interviewing. Now, there are laws that prohibit discrimination on the basis, again, of race, color, religion, gender, national origin, and disability. So, when we talk about getting into the interviewing for positions, it is illegal for an employer to try to determine the presence of a discrimination item during a pre-interview or an interview phase of hiring. So what that means is if I'm looking you up, trying to figure out who you are because you've applied for my job, I can't try to figure out what race you are, what your gender is, if you got kids, are you married? I can't do that. It's illegal for me to do that. And it's illegal for me to ask those items during the phase of an interview. Now, one caveat to this is when we come across a bona fide occupational qualification, okay? This is a job requirement that's normally discriminatory, but is allowed due to job specification, okay? Now, the example the book gives us on page 115 is if I'm hiring a men's bathroom attendant, okay, then I can make that so that job specification requires that be a man, okay? Or if I'm trying to hire a women's swimsuit model or a female swimsuit model, then I can specify in my job document that the applicant must be female, okay? So let's say I want to be CEO of a Baptist facility, then it's not out of the realm of possibility that you are asked during your interview, are you of a Baptist faith? Or if I'm interviewing for a position in a Catholic hospital, do you share the Catholic faith? So those, again, are things that are bona fide occupational qualifications. Normally discriminatory, but are allowed due to the job specification, okay? Now, a manager cannot ask inappropriate questions of an applicant, and a manager cannot use inappropriate information gathered in an interview to make a hiring decision. Now, sometimes some people will just overshare. They will tell you their entire life story during an interview, and they will share information with you that you're like, oh, I really wish you hadn't told me that. Or, you're talking about things like, well, I'm a single mother and I have 6 young children at home, all under the age of 8. Well, I know that it's tough to be a single mom, much less tough to be a single mom of 6 children under the age of 8. Now, I can't use that to determine whether or not I hire you because that's illegal, but you gave me the information. So see where it kind of gets a little sticky and a little iffy there? All right, flipping over to 116. Let's look at some inappropriate questions for job interviews. Now, Table 5, it says Table 5.1 in the slide, but it's actually Table 6.1. Okay, you cannot ask someone how old they are. What's your birth date? When did you graduate from high school? What year did you graduate from college? When do you plan to retire? Those are all absolutely inappropriate questions regarding age. Then you have religion. Well, do you regularly attend church? Which church do you go to? Do your parents or your husband or your wife or any of your family members go to church? Do you observe any religious holidays? You cannot ask those questions. Are you a naturalized or native-born citizen to the U.S.? Are your parents U.S. citizens? What about your spouse? Where were you born? You have an interesting name. Where does it come from? You cannot ask those questions. Are you married? Are you divorced? Are you separated? Are you widowed? What's your spouse's name? I see the diamond on your finger. Are you engaged? Are you going to get married soon? Do you plan to have children? Does your spouse's job require you to move a lot? You cannot ask those questions. Do you have children? How many? What are their names? How old are they? Do you have reliable childcare? Are you going to be at work on time? What's going to keep you from coming to work? Blah, 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 blah. You cannot ask these questions. Now, height or weight. How tall are you? How much do you weigh? Okay? This is another good example of a bona fide a bona fide occupational qualification. How much do you weigh? The only time that should be appropriate is if you are trying to get a job on a helicopter. So there are specific weight requirements for staff that work on helicopters, flight care. So that would be a bona fide occupational qualification for a specific job. But if you just ask me, who is a middle-aged, overweight white woman going to be working in an office, how much I weigh, well, guess what? That is so inappropriate. And again, some of these other ones, talking about workers' compensation, arrest record, military, disabilities, you cannot ask these questions. So these are all absolutely inappropriate questions. So when we get to chapter 8 and we're talking about recruiting for things and we're talking about recruiting for HIM jobs, part of your assignment is going to be to look at interview questions. And so you will come back and use table 6.1 in that assignment. Again, I'll remind you when we get to chapter 8. All right, so let's talk about counseling here. So for some new or even seasoned managers, employee counseling sessions are looked at in the same way as interviews. Managers are nervous. They will say something wrong or against the law. Despite these negative concerns, counseling is one management task that all managers have in common. And you may have counseling with your employees for lots of different reasons. So let's say you're trying to head off potential behavior issues, or you're addressing declining performance, or you want to give some career advice to a new recent grad that comes in and works in your department, or during training, or praising and encouraging, or coaching and mentoring. Now, regardless of the reason for counseling, common techniques exist to keep the HIM manager focused on the intent of the counseling session. And it goes on to talk about how all counseling should be done privately, and an appointment should be made so that both the employee and the manager know to expect a discussion. Because if I walk around to your cubicle and I say, "Can you step into my office right now?" that's going to freak you out. You know, it's nice for me to say instead, "Hey, I have something I need to talk to you about. Can we get together at 10:30 today?" You know, that's less worrisome than if I just say, "Can you step into my office for a moment?" You know, I don't necessarily want to hear either, but depending on how it comes across, it's much less trauma-inducing. All right, so let's move down to progressive discipline. This one's a tough one. So most of the time, counseling is done as part of disciplinary action. Discipline is necessary, if difficult, part of your job as an HIM manager. Now, even when expectations have been made clear, some employees fall short and need to be reminded of their responsibilities to their position and to the organization. So we have what we call progressive discipline to correct unwanted behavior, meaning that the first few infractions are treated with less severity than with later infractions. Okay? So a verbal warning is going to be our first step. Now, as soon as possible after the infraction occurs, I need to schedule some time privately to talk about the behavior with my employee. Now, at this time, I need to make it clear what the expected behavior is, what the incorrect behavior was, and the consequences of the incorrect behavior. Okay? And then what the consequences are if they continue to behave in that manner. So, again, verbal warning. Now, even though this is a verbal warning, I need to document it in writing. And it's going to stay in the department. It's going to go in my file as a manager or a department director. It's going to go in my file for that employee. It doesn't go anywhere else. It just goes there. So again, even though it's a verbal warning, I need to document that it took place. The date and time, what information I gave to the employee, if they had any response, and then we should both sign off on that just to prove that it happened. Okay? Now, the next warning, if behavior continues to degrade, is a written warning. So at that point, the same procedure is going to be followed for our verbal warning. But this time, when I document that in writing, I'm going to send it to Human Resources, and it's going to go in that employee's permanent file. Okay, so the verbal warning stayed internal to the department. It didn't affect their HR record at all. But when I get to that written warning, that's going out to HR. Okay, any manager, if like let's say you want to transfer to another department, the hiring manager has the right to go to HR and say, I need to see Tiffany Tubbs' file. And if they see written warnings in there, then that sets off some red flags as well. Maybe this person's not the right one for my job after all. Okay, now after the written warning, progressive steps are suspension. That could be with pay or without pay. And then finally, termination. Okay, so the verbal warning was really kind of a little tap on the hand. Hey, I need you to do better. This is what you need to do. This is what you were doing. This is what's going to happen if you continue to do what you're doing. You're going to get a written warning, and then you may be suspended with or without pay. And if you just keep continuing on doing it, I'm going to have to fire you. Then again, we get to that written warning. We continue to document the information. This time we're passing it on to HR. Okay, so that is what progressive discipline is. You start out light all the way up to termination. Okay, so let's look at termination for cause. So termination or dismissal for cause is generally the last step in our progressive discipline process. Now, this occurs when an employee has been taken through the whole progressive process, but their behavior has not changed. Termination at this point should not be a surprise for the employee because, again, you've laid the foundation starting with that verbal warning. If you continue along this path, this is going to happen. And then if you continue, then this is going to happen. And if you continue, we're going to have to fire you. So it should never be a surprise to the employee. Now, termination for cause can be used for immediate dismissal. In this case, progressive discipline steps are not implemented. So you can do something so bad that I'm not giving you a verbal warning. I'm sending you packing immediately. If you abuse a patient or another employee, you don't get a second chance. You're gone. If you falsify a medical record or an employee record, you are gone. If you steal something, you are gone. If you violate HIPAA, you are gone. If you are using drugs or drinking and you come into work and you are drunk, you are going home. Carrying a weapon into the facility and having a weapon while you are on the job, that is cause for immediate termination. Okay, so you have those 6 bullet points in the slides. You have it broken down into 7 bullet points in the chapter. Be familiar with those. Immediate termination. Okay. Now, moving over to 121. It says the HR department, we're still at the bottom of 120, the HR department must be involved if I'm going to terminate someone immediately, so that there's a third party making sure that all of my T's are crossed and all of my I's are dotted, that no discrimination has occurred. But in most organizations, employees have the right to due process in the termination decision or in any progressive discipline measure. Due process means that the employee has the right to make sure that their disciplinary action was carried out and in accordance with the organization's policies and procedures. Okay, so this process should be covered in our organization's policy and procedure manual. And there are many different grievance processes, but we have some general steps listed in figure 6.4. So the employee reports the issue to a supervisor or department director. The issue is reported to the next level of management. The issue is formally reported to the HR department. Then we have the HR department may utilize a committee to help solve the grievance, and then the employee may report the issues to the EEOC or to the State Division of Human Rights. So be familiar with that grievance process and those bullets there on page 121. It says any grievance should be handled fairly and objectively. In addition, a prompt decision at each level lets an employee know that their grievance was considered and acted on in a reasonable time frame. Neglecting a grievance or taking too long to answer leads to the creation of hard feelings if they're not already present. There are alternatives to the grievance process. And so now we're getting into mediation and arbitration over on 22. So the EEOC offers the option of mediation as an alternative to the traditional investigation or litigation process. Now, mediation involves both sides of the claim sitting down with a neutral third party and they reach an agreement. The mediator does not decide what the answer or solution is, but they help both sides come to a solution together. So most of the time, mediation is available at no cost. It doesn't cost anything at all. Each party has an equal say in the process and the settlement terms, and so there's no determination of guilt or innocence. All parties sign a confidentiality agreement. If mediation occurs early enough in the process, many are completed in one meeting, so you've got some time savings and some money savings there. And the whole intent is to avoid a more expensive investigation or even a litigation. So mediation uses a problem-solving approach that allows for reduced workplace disruptions, and this can lead to positive feelings after the issue is resolved, as each side has had a fair chance to present their side and work to arrive at a joint solution. Now that's mediation, but we also have arbitration. Now, in arbitration, again, it does involve a neutral third party. However, when you have arbitration, each party can present their side, but the arbitrator makes the decision. Okay? So in mediation, the arbitrator, again, the mediator was a third party, but they weren't making a decision. They were just kind of guiding discussion between each party. Now, in arbitration, the arbitrator is listening to both sides, but they're making the final decision. Okay? It says the arbitration decision is binding, meaning that before the start of arbitration, both parties agree that the arbitrator's decision will be final and that they both abide to the decision in this manner. So mediation, you kind of work together to come to a solution that benefits both of you. In arbitration, again, it's another third party, but they listen to both sides and they make the decision. And you can see in figure 6.5 the comparison of mediation and arbitration. All right, so that covers chapter 6. Again, I didn't cover every word, so be sure to read through your chapter, and you're going to have an assignment on discipline in this chapter, and then you're going to have an assignment based on the American with Disabilities Act. So kind of think through some of that when you're looking at reasons why an HIM manager would not hire a person with a disability. What kind of situation could you have going on? And there are some examples through the text. So if you read the text, you will see some of these examples. But I want you to think through that process. Think about what you saw when you went on the tour of the department last year, some of the jobs that they do, what you think would be a reason an HIM director would not hire someone with disabilities for, what kind of position, things like that. So if you have any questions about the assignments, you can let me know. Door's always open. And then, of course, you can always email. So happy reading. And